Today, we are talking about sexual harassment and how it can affect the workplace with decreased morale, can lead to chronic absenteeism, kind of a whole slew of negative things at the workplace, and how to try to prevent them. What are some things that you see, Tom, in handling complaints of sexual harassment for companies?
Sexual harassment is a very delicate matter, often because it requires a company to sort of put on their investigation hat and ask questions, delicate questions of the alleged victim, delicate questions of the alleged abuser or harasser. And so it requires a certain amount of strategy and diplomacy because the outcome is very important both for the employer and the person who made the complaint as well. Oftentimes, a person may come forth, and when the employer asks if there is any corroborating witnesses or evidence to show that the harassment exists, there may not be. And what does the employer do then? This adds a layer of difficulty because if after an investigation it's determined that the claims can't be substantiated, that doesn't leave the alleged victim with a lot of recourse to feel like he or she is being made whole.
And
What do you think are some ways that a company go about investigating these claims?
I think the first thing is to make sure that the person coming forward is actually being heard. I think that's really important. And I think it's something that most HR departments do overlook because it is such a sensitive topic and often can be also very graphic and can be embarrassing conversations that you're having as an employee with your superiors. So I think being sensitive to that and also really knowing how sexual harassment can impact the victim. So I think part of what HR needs to really take into account are the consequences of sexual harassment for the victim. So that could be decreased work performance, that could be increased absenteeism. There's a change in demeanor. But I would say that the most important thing is to listen. Just listen to the person.
I would agree. One of the major mistakes that an employer might make is to not properly document an allegation. Under the law, an employee only has to tell their supervisor or HR about a claim. So if it's a supervisor, that person also has to be trained on what to do. Now, the most obvious suggestion might be that the supervisor is trained to tell HR. And HR has more training about how to go to the alleged victim, how to speak with them, what sort of questions to ask. But making a record of the allegation is definitely the first place to start in an investigation because that is very common if an employee is making a claim of sexual harassment that finds itself in a court of law. One of the first pieces of evidence that's listed is no one ever made a record of the complaint I made. It's a show of indifference. That's a very easy step to overcome just by training your staff correctly on how to respond when someone makes such an allegation.
I think HR, the next step really needs to be interviewing the perpetrator to get both sides of the story. Due to the sensitive nature of sexual harassment, the perceptions can be just very different. And I would say that it's important to listen to the perpetrator just as well as it is to listen to the alleged victim, but to listen critically. I would say just listen extra critically, ask questions, be curious about what happened. And really about the relationship between the alleged victim and the perpetrator. I think asking some questions about that can help clarify the allegations themselves.
Definitely. I think in an interview with someone in HR, as two lawyers here who are in depositions regularly and had some training on how to depose a witness, one of the key things to do is ask a lot of who, what, when, where, why questions. You're asking open-ended questions to anyone you're interviewing because you want them to give you as much information as you can. Oftentimes when an investigator is sort of leading the investigation with a lot of do questions, was, were, questions that more or less elicit a yes or no response, you're not getting a lot of information because all you're getting is yes or no. You want to have all the details because after speaking with the victim and perhaps the alleged abuser or harasser, the next step is supervisors. You want to know what, if anything, was seen. You might want to know if this sort of incident had never been reported before by either the alleged victim or by the alleged harasser. That sort of thing is important when you take the totality of the facts that you have in determining what sort of decision the company is going to make on the accusation that's been made. So supervisors come next, perhaps coworkers after that. And then after you've gathered all this information, then HR interviewer may have to go to their supervisor to talk about the allegations and make a determination as to what to do next. So what happens next after all that information is gathered?
Well, really, it's to synthesize and make a credibility determination. And that's really difficult. Let's say you had two individuals with really stellar work histories, and it's really a he said, she said, or he said, she said, she said. I think that that is a really tough part. And I think, honestly, that should really be the point where they contact an attorney.
Right.
When they're starting to make those credibility determinations. I think that's really important.
The law is pretty clear that once an alleged victim has made a complaint, they have the right to escalate it further to a local EEO office or a state version of the EEOC. They have that right automatically. And what's very difficult is that if the claims are unsubstantiated, and remember, there is no proof requirement here. This is not a court of law. There is no substantial evidence requirement or beyond a reasonable doubt requirement. This is a company looking at the facts and doing its best to determine what they think the truth is. They may also make a determination that while maybe the claims are not substantiated, there is enough evidence that might infer that something like this may have happened, and they're going to make a determination on that. But regardless of what happens, regardless of the outcome, the person who is making the complaint doesn't necessarily go away just because you come to a conclusion, whether that's in their favor or not. When you have all the evidence together, it's definitely the time in which you hire or call an attorney, because it's time to sort of get a notion of what's the exposure here and what do we do? It might be as simple as, okay, we can't really substantiate anything. We're not necessarily going to discount anyone's veracity for the truth. So we can't fire anyone, but we can separate them. That's one option. Find a way to separate them out. There may be other options, but that's an obvious one. One of the best facts that an employer might have if they are sued is that they made proactive steps to try to separate the two individuals so that the alleged victim doesn't feel as though they are suffering from further discrimination, essentially being retaliated against by having nothing happen.
Exactly. And on that note, there's case law that says if the alleged victim is the one to face all the repercussions of the complaint, that really is retaliation. And you're putting the onus on that complaining employee to, let's say, take a night shift over a daytime shift in order to separate them. That is not good. You don't want to do that. You don't want to punish the person who's come forward because it's just not an easy place to be in. And certainly it's against the law.
Conversations about sexual harassment have come up a lot, maybe even the last 5 years. We know what's happened in our society. There's been a greater shift to put those claims in a closer focus. And that's a good thing. That's moving in the right direction. But it still does not mean that claims go uninvestigated, or that either because it's presumed that the victim is right, or that they go uninvestigated because it's presumed that the victim is trying to take advantage of something. A bias in that way is one of the biggest problems that an employer may face. A record of showing that the employer was always investigating this, always handled this in the exact same way and by the book is a great way to ensure that everyone's rights are at least cared for and that you're protecting the employer's liability as much as you can.
On that note, I would say an important thing to document is how you came to the conclusion that you did. Literally write down on a piece of paper or in a Word doc send an email to yourself about why you came to the decision that you did. Let's say to suspend someone or to move people apart or whatever. I think that's really important to include in a sexual harassment investigation.
After the decision is made, again, just a final record of what has occurred would be important. It would still be smart to speak to a lawyer because, like we said, there's no guarantee that that's the end of it, right? There may be further complaints coming from the alleged victim, but at least the company has properly recorded and can show the rationale behind the decision that it made.